Please be seated. As the two of you can probably tell, we only have one case on the calendar this morning. We have allotted 10 minutes to decide. If the appellant's ready, we'll hear from you.
Good morning. May it please the Court. My name is Martha Fernares, and I represent Alfredo Wong Pizarro.
You might want to see if you can't pull that a little closer to yourself.
Is this better?
Yeah.
There's a button there that.
There you go.
Get to where you're comfortable with
Okay.
it. That's great.
That's better? Okay, great. There's three things that I would like to discuss today. The first thing is a pretrial stipulation. The pretrial stipulation is really the parameter that we base what we're going to do at trial. In this particular instance, the employer carrier entered into a pretrial stipulation, agreed that the claimant was permanently and totally disabled, agreed that they had accepted the claimant as permanently and totally disabled, and that pretrial was approved by the judge of compensation claims in January of 05, January 23rd of 05. The surveillance that they're alleging is what brings about the misrepresentation fraud defense was taken in February of 04 and January of 05.
And was there a notice of denial filed based on the fraud defense?
There was a notice of denial filed based on the fraud defense in July of 05. And the pretrial was not amended till September of 05.
Well, you could still have a claimant who was PTD and yet not entitled to any further benefits because of intervening fraud, couldn't you?
Yes, you can, Your Honor. However, because they had the information, both the medical reports and the surveillance prior to entering to this pretrial stipulation, it is our position that they are stopped. They had the information available to them. Counsel in his brief states that he did not become aware or did not see the surveillance till June of 05.
Did you argue estoppel to the judge of compensation claims?
Yes, Your Honor. We argued that we didn't use the word estoppel, but we did say to the judge of compensation claims that they had accepted compensability, that they had not raised the fraud defense, and that they had not moved to amend the pretrial. We had a status conference, and during that status conference, we argued all this. At that point in time, the judge of compensation claims decided that she would let the opposing counsel amend the pretrial, which he did, and he would have to be more specific on the fraud allegations. In other words, what did my client do that they thought was fraudulent or misrepresentation? But I think that it's very important to note that the pretrial is not something that is totally useless or something that we should not address, because a pretrial is a stipulation, and if they had the information available to them at the time that stipulation was entered into, then the proper vehicle should be...
How were you harmed, other than the fact that the JCC concluded your client committed a fraud?
Well, Your Honor, we were harmed in that the court addresses in their order the issue of permanent total disability, although the court specifically stated that the only things that we were trying were the issue of compensability of the neck and shoulder condition, because the PTD did not become an issue till September of 05. So we were harmed in that the first depositions, if you note, the two doctors on which the court relies are Dr. Suarez and Dr. Diaz, and both of those doctors were previously deposed in the case prior to the employer carrier raising the fraud defense. And the testimony of the doctors was contradictory in both of these cases.
But only contradictory by virtue of the fact that in the second deposition, they viewed the surveillance tapes and they then gave an opinion based on that new information. Isn't that the basis of the contradiction?
I would like to disagree. It is not the basis of the contradiction because if you note, a lot of questioning was based on whether or not it was malingering, and the court, the judge of compensation claims, really uses the word malingering and the symptom magnification interchangeably, and they're not. If you look at the opinion of both of the doctors with respect to symptom magnification, you look at intent, and there is no intent if the claimant is portraying symptoms of symptom magnification versus malingering. Also, the opinions of these doctors was not contemporaneous with the alleged fraud or misrepresentation, because Dr. Suarez had last seen the claimant in September of 2003 and Dr. Diaz in February of 2003. The surveillance that we're talking about is February of 2004. So the judge is relying on medical opinions that are not current. This court in the past had said that 27 months in between the surveillance and the trial, or it's not adequate for a complete denial of a claimant's benefits.
My memory is that Dr. Diaz saw the claimant in the February, in the early 2004, which was about the time the claimant was also being followed. Is that not correct?
Your Honor, Dr. Diaz only saw the claimant for the first evaluation, and then his office staff, which consists of one social worker and 2 nurses, continued to treat the claimant. So Mr. Bustamante, whose deposition is part of the record, is the person who most saw the claimant in February of 2004. And in fact, in the notes of Mr. Bustamante for February of 2004 of this particular claimant, there is no notation of the claimant having an altered gait nor of using a cane.
Okay, I thought that there was the records for one of the times in February of 2004 indicated the claimant was using a cane, and another one indicated that the claimant wasn't using a cane. So they weren't inconsistent, but one time the claimant apparently was using a cane and one time he wasn't.
If you notice, there's a 5, and I go into this in the deposition of Mr. Bustamante, there is a 5-week interval wherein the claimant goes from 5 weeks, and then he comes back in January to Dr. Diaz's office, and it's very important to note that it's not Dr. Diaz who sees the claimant, but his office staff. Dr. Diaz may have discussed the case with his office staff during office meetings, but he himself does not see the claimant. So the judge of compensation claims is relying on the opinion of doctors that did not see the claimant during that time. That is why it's our position that the competent substantial evidence that she's relying on is deficient. Excuse me.
Thank you. You've got just under 2 minutes for rebuttal.
May it please the Court, Douglas Barnes on behalf of the appellees in this matter. I represent Costco and Sedgwick Claims Management. The standard of review in this case is competent substantial evidence. The testimony of the claimant is the critical factor in this case as far as we're concerned. In his initial deposition, 72202...
Before we get to there, address the pretrial stipulation argument, if you would, because it seems to me that we don't want to encourage an ambush at the final hearing with respect to an issue that's not raised in the pretrial stip, and I'm concerned that the PTD issue, as it relates to fraud, was not raised. Would you address that?
Yes, sir. In regards to the pretrial, what we stated in the pretrial was simply a fact that had occurred previously, which was that the claimant had been previously administratively accepted as permanently and totally disabled. That was a fact that was present at the time that pretrial was completed. And the employer carrier at that time did not raise a fraud defense. We raised it subsequent to that time. And during that time, the claimant was receiving permanent total disability benefits and continued to receive those permanent total disability benefits until we raised the misrepresentation defense in July of 2005. And at that point, then we proceeded with raising those issues. This is not a case where the claimant was ambushed at trial like Green Iguana raised on the day of the trial.
But the notice of denial in July did not relate to the PTD, did it?
It denied any and all further benefits based upon the claimant's false and or misleading statements. And PTD was one of those benefits that was being paid. We subsequently amended the pretrial to that, as counsel indicated, in September of 2005. The trial was not until January of 2006. That's when, so there was plenty of time.
And to refresh my memory, the amendment to the pretrial STIP specifically referred to PTD?
It referred to any and all benefits being denied based upon the false and or misleading statements. The judge, as counsel alluded to, at the status conference, made the employer servicing agent file a memo of law stating with particularity, and it was if I'm not mistaken, at least a 5 or 6 page document that was filed at that time alluding to the pages of the deposition, the specific references to the doctor's testimony. At that point in time, the doctor's depositions had been taken the second time, and they had had the opportunity to review.
So that was December 2005?
No, that was in September of 2005, I believe.
I thought when were the doctor's second depositions taken? I thought it was later.
I believe that they were taken, I don't recall, I don't have that date handy, Your Honor, quite candidly. I thought they were taken before the amendment to pretrial, but I'm not sure. They could have been after that. But nonetheless, they were the facts that were relied upon in denying the benefits were raised in that memo. They were discussed with counsel. When I first became aware of the surveillance, I immediately produced the surveillance. The surveillance was produced within a matter of a week after I became aware of it, and they had an opportunity to review it. They reviewed the surveillance before we went and took the doctor's depositions. So there's no ambush here. There's no trial by gotcha. They had plenty of opportunity to raise all of these issues, had plenty of opportunities to defend the claim. The claimant even reviewed the surveillance. We took an update deposition of the claimant after he had taken or had an opportunity to review the surveillance. And even in that deposition, again, after being warned about making false and or misleading statements at the beginning of the deposition, still testified contrary to what was depicted on the surveillance of February 16, 2004, which he said he was still having problems driving. He was still having to lift his leg in and out of the vehicle. The surveillance clearly showed him driving without any difficulty getting in and out of his vehicle, and that he was walking without a cane, without a limp, was able to climb stairs without any problems. All of these things have been testified contrary by the claimant. The claimant's own testimony is the most significant evidence in this case as to his false or misleading statements. The doctors reviewed it. They were concerned even before they viewed the surveillance as to symptom magnification and or malingering. And once they reviewed that surveillance, they concluded that there was a grave concern about malingering and concluded that the presentation of the claimant to each of those doctors in their offices was inconsistent with the surveillance. And it's also important to note that the surveillance of January 13, 2005 showed the claimant going into Dr. Diaz's office, which is the way Dr. Diaz testified he presented in his office, which was using a cane in the right hand, ambulating in a very bizarre pattern, unable to go upstairs except one at a time, holding onto the railing, holding onto the cane. Again, this is directly contrary to the surveillance on February 16, 2004, which he was walking normally, and the doctors could not explain his bizarre presentation as far as the gait use of the cane and things of that nature. And like I said, they were concerned about that even before viewing the surveillance. The surveillance was relied upon by the judge. There was 2 investigators that testified. They also confirmed that they observed the claimant driving in a reckless manner, which is contrary to his testimony that he was afraid as to how he was driving because of the fact that he was afraid that his right leg would not be able to be used to step on the brake, and consequently he had to drive very slowly and very cautiously. The judge had the opportunity to review the surveillance, the doctor's testimony, observe the demeanor of the witnesses, in particular the claimant as well. He, again, at the hearing, presented himself in such a way that I believe the judge found it was inconsistent with the surveillance and how he was acting at that time, which was he was having difficulty standing, walking, pain behavior during the course of the final hearing. Those are things that the judge had the opportunity to observe during the final hearing. I think those are also significant. I believe that the court should affirm the decision. There is more than competent substantial evidence in this case, and the court should deny any claim for attorney's fees. Thank you.
Thank you.
The first thing that I want to address with the court in rebuttal is that the PTD was not an issue. The PTD was not tried. Why the judge made a finding as to the continuing PTD benefits is beyond me,
Because if you commit fraud, you're not entitled to any further benefits.
You're absolutely correct, Your Honor. If you commit fraud, you're not entitled to any other benefits. But PTD was not tried. PTD was not an issue. So
it was a benefit he was receiving.
He wasn't receiving PTD benefits at the time of the final hearing.
Because they had stopped.
They had stopped in September of 2005. So at that point in time, this is like the First District case opinion wherein you rule that if the claimant committed fraud in order to continue with his employment, he did not commit fraud for purposes of his workers' compensation claim. The claimant here was receiving both indemnity and medical benefits at the time of all of his depositions. He was receiving the most you could receive, which was the permanent total disability. So the alleged fraud was the altered gait and the using of a cane. How is that related to the neck and shoulder injury? I think that...
But you don't deny that there's finding that the claimant committed fraud to receive workers' compensation benefits.
I am denying, Your Honor, that he had any intent to commit fraud. I think that intent is not clear in this case, and since he was receiving the most that he could receive during the time that he committed the alleged fraud. So where is the intent to commit fraud?
To continue to receive it.
There was nothing before the courts or nothing as with respect to a claim seeking benefits with respect to his altered gait. He was accepted as permanently and totally disabled and based on an administrative decision when every doctor that he was treating was saying that he could work.
But it's fairly fundamental that if in fact this man was not permanently and totally disabled and was faking the extent of his injuries to make it look like he was, that would be fraud, wouldn't it?
Absolutely, Your Honor. But you must remember that the surveillance where he is acting without an altered gait and without a cane is actually a February of 2004 surveillance. And the contemporaneous medical records for that time frame, which is Dr. Sharon and Mr. Bustamante, do not show the claimant with an altered gait or using of a cane. The surveillance that was done in January of 2005 depicts the claimant exactly as he was at that point in time and as the medical records indicate that he was at that point in time. And there could be a change of condition, and the court never took that into consideration. That's why we're saying that the opinions which the court based her decision are incorrect because they're legally insufficient to be competent substantial evidence.
Thank you, counsel. You're well over your rebuttal time. That concludes our calendar for this morning. We'll be in recess.